Hello friends, in the series on the income tax cases, today we will discuss a case in which there was an issue of claiming deduction under section 80IA. We all know that section 80IA deduction is regarding deduction in respect of profits and gains from industrial undertakings or enterprises engaged in infrastructure development. In the present case, a very limited issue was before Chennai ITAT D bench that for the purpose of claiming the deduction under section 80IA for a captive power consumption units, which rate is to be taken, whether it is the rate at which the power distribution companies supply electricity to the consumers or the rate at which the captive power consumption units supply excess electricity to these distribution companies. This issue has been taken up by Honorable Chennai ITAT in the case of Assistant Commissioner of Income Tax versus Tamilnadu NEWSPRINT and Papers Limited. This case is reported in 129 ITR Tribunal at page number 138, and the date of the judgment is 30th November 2023. The present case relates to the assessment year 16-17. In the present case, already the CIT appeal has ruled in favor of the assessee. The appeal of the revenue was delayed, but when the condonation application was heard, the tribunal said that in the present case the delay was not wanton or willful, so the condonation was allowed. In the present case, the assessee is in the business of manufacture of papers, power, energy and cement, and the assessee was having two captive power unit eligible for deduction under section 80IA. Excess power generated by the assessee during the year was supplied to a company T, which was a power distribution company at the rate of 5.11 rupees per unit, and minor quantity of power was also supplied to a company RSY at rupees 9.1 per unit. Assessee claimed deduction under section 80IA for captive power consumption from its eligible unit at the rate of rupees 6.35. When the assessment proceedings were going on, the matter was referred to the transfer pricing officer for calculating the arm's length price of this captive power consumption. The TPO said that assessee had shown to have purchased power at rupees 6.35 per unit, which was charged at the rate of which was charged by company T. Since in the present case the assessee has supplied the power at rupees 5.11 per unit, so this rate is to be taken for calculating the deduction under section 80IA. So accordingly, the assessing officer on the basis of the report of the transfer pricing officer made the addition for the difference and took the rate of rupees 5.11 per unit, which is the rate at which the captive power consumption supplies goods to the distribution companies. When the matter was at the stage of CIT appeal, the CIT appeal said that it is a well settled law that the rate at which the power distribution company supplies power to the consumers should be taken for calculating the deduction under section 80IA. The revenue filed the appeal before the tribunal, and when this matter was heard by tribunal, the tribunal was also of the view that the assessing officer has erred in making the addition under section 80IA by taking the rate of rupees 5.11 at which the captive power units had supplied the electricity to the distribution companies, but the exact position of law is that rate should be taken for calculating the 80IA deduction at which the power distribution company supplies electricity to the consumers. At the end of this video, once again I am repeating the name of the case. The name of the cases Assistant Commissioner of Income Tax versus Tamilnadu, Newsprint and Papers Limited, and this case is reported in 129 ITR Tribunal at page number 138, and the date of the judgment is 30th November 2023. Thank you, friends.